Good morning, you're watching Business Plus. I'm Karthik Malhotra, an action-packed next 25 minutes or so with all the top stories making headlines in the world of business. First up, let's look at the headlines. Well, Adani-Hindenburg saga, Supreme Court defers its judgment on November 24th, but markets rally on account of Adani Group stocks. Is it the end of the saga or the opening of a new episode? Step down BYJU Raveendran, comes the word from shareholders. Terms and conditions in place to infuse fresh capital into BYJUs. And there's an irony playing out at Raymond's. Gautam Singhania, the complete or the incomplete man, we discuss. CLSA, global brokering firm, says India is likely to be the largest economy in the world, surpassing US by 2052. And the critical minerals auction starts today. Will it lead to India being Atmanirbhar, especially when it comes to electric mobility? And finally, in sad news coming in from the US, Charlie Munger, the renowned investor, is no more. Let's get straight into the big story. Yesterday, we saw Adani Group stocks rally, many of them hitting the upper circuit as well. This came since Monday was a closed day for Indian stock markets, and the Friday deferment of the judgment on the ongoing Adani-Hindenburg saga by the Supreme Court resulted in stocks rallying yesterday, and that momentum seems to be true today as well, with Adani Enterprises in the green. Now, what's really gone on? Can we conclusively say that there is nothing for the Supreme Court to find as misgovernance or misdoing on account of the Hindenburg research, which the Supreme Court again has said that is no real benchmark to base a judgment on? At the same time, SEBI says that it has completed 22 out of the 24 cases pending with it. Stocks continue to rally. Let's try and make sense of whatever has happened in that hearing of the Supreme Court on November 24th with the Managing Director of InGovern Research joining us live this morning, Mr. Sriram Subramaniam. Mr. Subramaniam, thank you so much for joining us this morning. To begin with, markets seem to once again be seeing the fact that Supreme Court deferring its judgment is perhaps in some way a sort of green chit to Adani. At least that is the sentiment. The green shoots on Adani stock seems like a green chit. But that does not seem to be the case, Mr. Subramaniam, is it?
Yes, I think we have to still wait for the final order by the Supreme Court but obviously stock markets always work on expectation. So the expectation is that this would be I would say, a clean chit in that sense of, at least from the tone that the petitioners had used data points which were not sort of relevant, etc. The tone of the Supreme Court was very acerbic, and the petitioners were dismissive of the petitioners. So to that extent, I think the markets are expecting that the final order will also be in favor of the Adani Group.
Okay, so Mr. Subramaniam, at one point the Supreme Court is saying that we should not consider Hindenburg research, or for that matter any of the other journalistic publications in the world, to be treated as statements of truth or gospels of truth. And at the same time, the Supreme Court is asking SEBI on what SEBI is doing to tighten the noose around shareholders losing wealth on account of such cases, and such cases being referred to as the Adani-Hindenburg saga. So, is the ball now really back in the court of SEBI? And what are the next steps from here? When do we expect SEBI to finally have some sort of a disclosure?
Yeah, in fact, unfortunately, the Adani Group is such a large group that right from January, I have been commenting, and when we put out our first report also, we said the remit and the regulator to look into this is only SEBI. It took political overtones, and there was ruckus in parliament, and there was issues, and these petitioners put it in Supreme Court. These are all tamashas, I would think. Supreme Court appointing some committee to look into it, etc. SEBI is a regulator who is mandated to look into security issues, if there is a violation of the minimum public shareholding, which is the crux of the whole issue, it is in the court of SEBI. Now, SEBI has said 24 out of 24 points they have investigated, 22. So the remaining two investigate, get done with it, and then whatever is the issue, put it out in the public domain and bring this entire 24 issues to a close. Whatever it be, even Adani would want. If they have to pay a fine, they'll pay a fine. If they have to do some action, they will do. I mean, it cannot be left in limbo, and it cannot be left to these random petitioners taking it to the court of law where they don't even have a shareholding. I mean, these petitioners. So, on what grounds are they petitioning?
But Mr. Subramaniam, I want to understand these two matters which have been pending with SEBI for the longest time now. In fact, if you remember, in the month of May is when the Supreme Court had given directions to SEBI to conclude its investigations by 14th of August. And then 14th August, followed by September, October, November, we've seen this deferment of SEBI presenting its report to the Supreme Court, or to the public for that matter. Now, these two matters which are pending with the SEBI, with the regulator, seem to be matters where SEBI is continuing to be hit by what are referred to as opaque structures, and its jurisdiction outside of the shores of India is preventing it from completing its investigation. So what are the options available with SEBI, number one, and number two, even if it continues to be this way, that it is unable to penetrate those opaque structures? By when should the regulator finally be expected to make a full public disclosure of its findings?
Yeah, I would think that at the end of the day, the regulator should try to make its disclosures as early as possible. I think even if it is able to bring closure to 22 out of the 24, let it put out the findings of the 22 issues or at least bring closure to those 22 issues. And then the remaining two can be taken up later, or at least SEBI can put out that they are unable to get data, and that's where they are unable to come to a conclusive end to those two issues.
Okay.
At least there is certainty and closure to those 22 issues. Then.
Okay. I want to just take you back, Mr. Subramaniam, to two statements that have come out over this long period of the ongoing investigations and the deferment of hearing dates, and now, of course, there is a reservation on the judgment as well. But the two specific instances have been that the Supreme Court appointed expert committee did not prima facie find any wrongdoing on account of SEBI. And even the Supreme Court on Friday said that it does not find enough material evidence to find that SEBI has actually not done its job correctly as a regulator. So does this mean that SEBI and whatever investigations before even the Hindenburg research report came out, and obviously after that as well, has put a complete clean sheet, green tick on account of SEBI? And at the same time, SEBI in its own probe, in its own investigations, has not found any sort of manipulation of stock prices. Is that a fair assessment to make?
No, I would think one is SEBI. All that the Supreme Court and the expert committee are saying is that SEBI is doing its job. There was a perception that SEBI was not doing its job. This committee and Supreme Court has just said that SEBI is doing its job, albeit probably slowly because of data, because of foreign jurisdiction, etc., etc. But after that, has SEBI given a clean sheet to Adani's? No, not yet. Right? We don't know what are the findings of those 22 at least items. What are the findings of the two which are yet to be sort of brought to a closure? So I would still reserve judgment on the Adani Group stocks itself. But all said and done, it should be the remit of SEBI. It should not go to Supreme Court and the like and become a political tamasha, if anything. Because Adani Group, yes, it is politically connected probably. But all said and done, this is a securities matter, and it should have been dealt with from a mature securities matter perspective.
In your own experience, sir, in your professional and personal experience, dealing with the regulator, dealing with bodies that protect shareholder interests, is 1 year an okay time for a regulator to conclusively disclose its findings, or do you think it should take more time before it comes out with a final disclosure?
No, 1 year is a reasonable long time, but there could be constraints if there are foreign holdings and the like, because it also depends on the foreign regulators' inputs and the speed at which the foreign regulators work. Right, I mean, SEBI, the intermediaries under which SEBI has control over, like Indian intermediaries, brokerage firms, etc., can give data quite fast, and SEBI can conclude investigations within 1 year in India. But if data points are required from abroad, that may be taking time.
Right. And the Supreme Court reserving its judgment, sir, whenever the judgment is finally passed, is that judgment going to be specifically on account of the Adani-Hindenburg research report, or is it going to be on account of SEBI doing its investigation correctly or incorrectly, and hence some sort of action? What is the report, final report from the Supreme Court, the verdict from the Supreme Court likely to look like?
Yeah, I would think it will be more on the SEBI's investigation. There should be no credence, and Supreme Court has already sort of this one admonished the petitioner, saying that one should not rely on Hindenburg or OCCRP or whoever it is, right? These are third-party research agencies. I mean, the court cannot rely on some third-party research output, and those people have they are interested parties. In fact, Supreme Court admonished the petitioner themselves that their interest is quite, there is a conflict of interest, and that itself is telling. So Supreme Court should just rely on what is SEBI findings are, and rely on SEBI's findings, SEBI's inputs, and the like. And whatever order they come out with, I would think that they would again point out to SEBI itself and bring closure to the matter.
All right, hoping for a quick closure to the matter. Mr. Subramaniam, stay with us. There's another two very interesting stories which are making headlines last few weeks, and we'd love to have your inputs on those as well. And let's move on to one of those stories. If Raymond's were to come out with a creative tagline for its men's apparel business in November 2023, perhaps the idea of the tagline being "the complete man" would likely be shot down. Its chairman and managing director Gautam Singhania is in the eye of a storm that borders both professional as well as personal boundaries. Well, Gautam Singhania is no stranger. He's known for his flashy cars and bratish attitude. Gautam Singhania first lost his moral standing after he allegedly threw out his father, the founder of Raymond's, Vijaypat Singhania, after the father gave Gautam Singhania control of the entire business and all his wealth. A decision the 85-year-old, once doyen of the industry, now regrets. And now, a messy divorce with his now estranged wife, Nawaz Modi, is making headlines. There are allegations of violence, physical assault perpetrated on his wife against the top man of a company that represented chivalry and family values as a key to success, with its tagline, like I mentioned, "the complete man." In the latest development, proxies to shareholders or associations that represent the voice of shareholders have come out and said that Raymond's must launch an investigation into the charges of violence as well as misuse of company funds against Gautam Singhania. It has asked for the company to separate itself dispassionately from its management. In effect, IIAS, or Institutional Investor Advisory Services, has asked Gautam Singhania to step down and an interim CEO to take charge while the investigation is conducted. Moreover, it has advised the board of directors to retain an independent counsel to protect and delineate themselves from the allegations. But getting rid of the chairman and managing director, especially one that has his last name as Singhania, is not going to be an easy task for the board of Raymond's. Mr. Sriram Subramaniam continues to be with us. Mr. Subramaniam, what options does the board at Raymond's have?
Definitely, I think the board should act in the interest not of Gautam Singhania, but in the interest of the other shareholders, in the interest of protecting the company and insulating the company, I would think, from the family dispute in that sense. Because one, the wealth is going to be divided for sure. Two is the day-to-day operations of the company should not suffer. Because the bandwidth of Gautam Singhania will obviously be drawn towards the divorce, and as you said, it is going to be messy. Three is obviously the allegations of utilization of company funds for all these should definitely be looked into by the independent directors, and the companies should be protected. For example, if the company is funding even the lawyer costs for the divers, that should not be a no-no. Because Gautam Singhania is supposed to use his own money to fund a lawyer's bills. So these are the issues I would think that the independent director should work towards protecting. It could well be that Gautam Singhania is asked to step down. A new interim CEO is brought in, or somebody who is already currently in the management is made a MD or interim CEO, and the company is run on a day-to-day basis. These are the many steps that the directors of Raymond should definitely take. It's not a small company, it's a large company with other stakeholders also.
But Mr. Subramaniam, I think the funding of lawyers, the infusion or misuse, so to speak, of company funds is one matter. There is also a sort of moral standing question that comes into being with whatever allegations right now have been made against Gautam Singhania. Now, if these allegations, obviously they need to be investigated, and there would be an investigation, that would be done. But should the company initiate its own independent investigation as a responsible company, as a responsible corporate citizen? Should Raymond's take the moral standing of trying to get rid of, it's not going to be an easy task, it's going to be an uphill climb, but try to get rid of, at least temporarily, until the investigations are on and have conclusively ended in any direction, get Gautam Singhania out of the office?
No, I think, I think you have multiple dimensions out there. One is, should the company investigate the charges of assault, etc.? I think that is definitely no, because that's a domestic matter to that extent. Individuals have their own behaviors, etc. So the company is not so much bothered about the assault charges. That is for some criminal matter and or his wife to pursue it and but what the company should do is at least not utilize the funds of the company for any of these matters. The allegations of, if anything, misuse of funds of the company in the past should definitely be investigated, if anything. And going forward also, the company's fund should be insulated from these diverse, I would think, at least utilization towards that extent, right?
Right. So the word coming in from Sriram Subramaniam there. So stay with us. We've got one more story to get your inputs on. The word coming in from Sriram Subramaniam there that the board, the independent board and the company should only be bothered about the utilization or misutilization, as the case may be, of funds for personal matters. And of course, the second issue really being about the bandwidth of Gautam Singhania to lead operations at Raymond's, and perhaps an interim CEO should take charge to at least ensure that the day-to-day operations of the company do not suffer. But let's move on for now, and let's move on to the beleaguered Edtech startup BYJU's, whose troubles never seem to end. And in the latest round of troubles, in fact, 2 rounds of troubles coming the way of BYJU Raveendran now. Number one, BYJU Raveendran's shareholders are now saying that they will infuse fresh cash into the company only if certain terms and conditions are met. What are these terms and conditions? Well, one of them also involves the suggestion, if not an advice or a direction, for BYJU Raveendran himself to sidestep, to move aside and make way for better, more professional, more transparent management to come in. And the other is by way of BCCI, the Board of Cricket Council of India, now looking at suing BYJU's for not living up to its advertising contract and not paying BCCI. Troubles never seem to end for BYJU Raveendran. But the question we want to know and get an answer to today is that, is it time for BYJU Raveendran to get out of this mess, to let a new management, a new CEO clean up after him? Mr. Subramaniam, thank you for staying on with us. BYJU Raveendran, once celebrated as the hero of startups, representing the most valued Indian startup at $22.8 billion, and now this fall from grace. The issues never seem to end. They are yet to file their audited reports for FY23. 31st March 2023 is when the financial year ended. We're almost 8 months or so into the new financial year. And in fact, even FY22 reports, audited financials were filed only in the first week of November, a good 18-19 months after the year ended. And troubles on account of investments, on account of written down values on books of investors, on a Term B loan of $1.2 billion, distressed sale of Great Learning and Epic yet to take off, a David Kempner loan of about $400 million or so paid by Ranjan Pai, a new board because the old board felt there are enough and more governance issues for them to continue on the board. What is really going on, and how should an unlisted company like BYJU's take it from here?
Obviously, all the misdeeds of the past is sort of seem to be coming to haunt BYJU's. And the explosive growth, or I would say the not putting in place processes and ethics and compliance matters, all are coming to haunt them at one go. But coming to your specific question of investors are demanding BYJU's to step down, this I had told when the three investor directors stepped off of the board in July or August earlier this year, that if anything, if they wanted to save the company, it should have been the founder directors, the three of them, who should have been kicked out, not the investor directors who should have been on the board, who should have left the board. Yeah. Because at the end of the day, it is the BYJU's as a company needs to be saved from the founders, not from others.
So right? Is it time for BYJU, Raveendran, to step down? In your independent view, you're not an investor, there are no public shareholding of BYJU's, but in your personal opinion, if this is not the time for BYJU, Raveendran, to step down, then when would be the right time?
Yes, that's the entire point. That's where now investors are saying it is time for BYJU's to step down, and then we can infuse more funds to at least save the company. Because otherwise, without funds, BYJU's needs some breathing funds. It is not going to be able to sell off Epic or Great Learning in a hurry, because at the end of the day, they may be expecting $1 billion, etc. All those who are is going to be a buyer knows that BYJU's is in distress. So it's not going to be easy to sell those assets off. BYJU's can keep making media statements, etc. But the investors know that it's not going to happen. So if anything, there has to be a rights issue. The current set of shareholders have only to infuse more funds to at least keep some kitchen fire burning kind of a funds to BYJU's to at least be compliant with the laws of the land. For example, they may not have paid TDS, EPF, etc., Employees Provident Fund, all these GST payments, etc. So all these at least compliance things should be done with. So for that matter, if shareholders are to infuse new funds, they are expecting BYJU's to step off, which is fair.
All right, Mr. Sriram Subramaniam, pleasure having you this morning on these very important stories, and we'll keep coming back to you for your inputs as we move on. But for now, thank you so much for joining us. Well, let's move on from this power-packed discussion that we've had. Let's move on to something good, something to give us some cheer this morning, and that is a report coming in from the global brokerage, the global broking house or ratings agency, CLSA. And what is CLSA saying? CLSA is saying that India would become the world's largest economy by 2052. That's right. 5 years after India completes the Amrit Kaal, or 100 years of India's independence, India's GDP is likely to surpass that of US, with the nominal GDP at $45 trillion. India is also likely to exceed Japan to become the world's third largest economy in just about 3.5–4 years from now, by 2027. And by the end of Amrit Kaal, or 100 years of India's independence, CLSA's estimates coming in line with the government's. The government pegging India to be a $30 trillion economy. CLSA just a couple of trillion short at about 29 trillion. And India's current economy, of course, is upwards of 3.4 trillion. Some estimates suggest $3.75 trillion has been achieved. And CLSA saying that by the turn of the decade, by 2031 or so, India's economy could be in the vicinity of $7 trillion. Again, a year or two here or there, but estimates coming in line with what the government of India is also stating. And India's economy, of course, is expected to grow at 6.4%, about a 0.1%, 10 basis points short of RBI's projection of 6.5%. And CLSA, of course, continuing to be bullish on India. And let's move on now to another interesting story which is been in the making for the last almost 6 months or so, and that is India being self-reliant on its energy needs, and especially its energy needs when it comes to electric mobility powered by lithium-ion batteries and lithium reserves found in India. The amendment to the Minerals Act has been made, and the centre is going to commence the auctioning of 20 critical mineral blocks starting today, November 29th. And this first round of auction and the subsequent rounds for critical minerals will include mining of lithium as well as graphite, both critical to India's landmark initiative to boost the economy as well as be self-reliant when it comes to energy production, clean energy, green energy, electric battery production. Now, these auctions are going to be conducted in an online format, and the attempt to transfer underutilized assets to the private sector is what is prompting these auctions. Of course, the government had earlier announced a 3%, a 1% to 3% royalty, which the government would make on all of these blocks when production eventually begins. And 10 to 12 players from the private sector have reportedly got the technology to produce and process these critical minerals. And well, to close this bulletin, on a sad news coming in all the way from US, we are talking about Charlie Munger, the longtime vice chairman and second in command to Warren Buffett at Berkshire Hathaway, has passed away. He died on Tuesday morning US time, that's November 28th, at a California hospital. Munger was 99 and would have turned 100 on Jan 1st, 2024. He died peacefully as per reports, and a statement coming in for Berkshire Hathaway. No cause for his death was given. Now, to quote Warren Buffett, Berkshire Hathaway could not have been built to its present status without Charlie's inspiration, wisdom, and participation. Munger had been a Berkshire vice chairman since 1978, working closely with Buffett on allocating the Omaha, Nebraska-based conglomerate's capital and being quick to tell him when he was making a mistake. Well, the death of Munger is unlikely to have a major impact on Berkshire's operations. Two other vice chairmen, Greg Abel and Ajit Jain, have day-to-day oversight of Berkshire and dozens of its operating business. Abel is expected to become the chief executive officer once Buffett is no longer in charge. Well, with that, we are completely out of time on this edition of Business Plus. Thank you very much indeed for watching. We'll be back on the other side of this break with World Business Report.
Hamas attacks Israel.